I can't actually, I cannot hear you. Let me just check something quickly.
Hello? Ma'am, can you hear me? Yeah, what do you...
Okay, Mr. Gora, I've shared a screen. If you can just give me a thumbs up if you can see the shared screen. Okay, great. Just switch your mic. I just want to try something quickly before I start teaching. Switch your microphone on again and just try speaking. I want to see if it's perhaps my headphones that are problematic.
Hello?
Okay, now I can hear you. So it seems my headphones that I was wearing were problematic. Okay, right. Let's carry on. We had to stop rather abruptly during the vocation school that I offered on Tuesday morning because of connectivity issues. That lecture has since been uploaded onto my YouTube channel. I've shared the link also on the WhatsApp group, so you can access it there. So I'm going to carry on jump in straight away and carry on from where we were. We're looking at the law of contracts at the moment. We've looked at the 5 requirements for a valid contract. If I can go up there, those are the 5 requirements for a valid contract. If any one of those requirements is missing, that means the contract is not valid or it is void. A void contract is a nothing. There are no rights and duties that flow from a void contract. Then we proceeded to look at the separate requirements one by one. We spent some time looking at consensus. Consensus, the complete agreement about the same thing, the same understanding about the obligations. So we looked at consensus, also certain instances where there is consensus, but there's something wrong with it because it was obtained in the wrong manner, which means the contract is then voidable. It can be set aside. But until it has been set aside, it remains valid. I need to add this here to these notes. It remains valid. Then, having completed our look at consensus, we started looking one by one at the other 5 requirements, and that is what I want to finish this morning. The first one we looked at is contractual capacity. Contractual capacity based on the ability to understand. To put that in context, there must be consensus. Consensus is a complete agreement. Requirements for consensus, there must be the serious intention to become legally bound, and the parties must be aware of the legal consequences. They must understand it. In order to reach consensus, in order to understand these consequences, there are factors that can influence your understanding, amongst other things, your age and your mental health. In certain instances, your status also influences your contractual capacity. That, however, falls outside the scope of our syllabus. So we looked at age, and then where we stopped on Tuesday was we were looking at mental health. Many textbooks still use the terminology of somebody being declared insane. I don't particularly like using the word insane. I prefer using mentally incapacitated. You can use either. Somebody has been declared mentally incapacitated. They have no contractual capacity, but can still have a clear moment during which they understand, they have the ability to understand whatever contract they are getting in. If somebody wants to hold another person to a contract and this person has been declared insane, the initial position will be that the contract is not valid because of their lack of contractual capacity. Person that wants to hold them to the contract will have to prove, has the burden of proof that they were acting in a clear moment and accordingly had contractual capacity. Intoxication, this is where we stopped. Intoxication is similar. Intoxication being under the influence of not only alcohol, but also any medication, drugs, etc., which can affect your ability to understand. Intoxication, however, it works the other way around to somebody that has been declared mentally incapacitated. So the person who claims intoxicated must prove this. So a person above the age, what that comes down to, a person above the age of 18 is deemed to have contractual capacity. But if you sold your car for $100 after a long night at the shebeen, and the next day you wake up and you want to get out of this contract, you want this contract to be declared void because of your lack of ability to understand, your lack of serious intention to enter into this contract, you will have to prove that you were so intoxicated that you could not understand this. Okay, moving on then to, so that is legal contractual capacity. The next requirement is that performance must be possible. Performance must be possible. The obligations agreed to in terms of the contract must be possible to perform, and this is important, at the time of contracting. So we're not talking about a week later or a month later, whatever. We're talking about when consensus is reached at the time of contracting. The performance must actually be possible. Possibility of performance relates to two aspects. Performance can only be possible if you know what the performance is. It must be determined or determinable. You must be able to establish what is expected of you. And then it must be actually possible to do this. Contract, for example, Mr. Gora. If I enter into a contract with you that I will sell you all the diamonds that I can mine on the moon, will that be a valid contract? Yes or no?
Sorry, ma'am, I didn't get that.
We're busy with the requirement that performance must be possible. So
Yes.
I enter into a contract with you that I will sell you all the diamonds that I can mine on the moon. Is that a
Yes.
valid contract?
I don't think it is if there's no consensus between you and I. Yes, you
And then
can
we're not,
offer
sorry, can
the
I interrupt? We're not talking about consensus. We're looking at the requirement that performance must be possible. There is consensus. We have agreed. You agreed to buy from me all the diamonds that I can buy, can mine on the moon.
yeah.
Is that a valid contract?
I don't think so.
Why not?
Because
You're correct, but why not?
are you able to render the performance of the contract? That's
Exactly. I cannot perform. It is not possible for me
yeah.
to mine diamonds on the moon. So even if we've got a complete agreement, we've got consensus, it's still not a valid contract because performance is not possible. With regard to the possibility of performance, however, we need to distinguish between subjective possibility and
Yes, ma'am.
objective. Yes, Mr. Gora.
Yes.
We need to distinguish between subjective impossibility of performance and objective impossibility of performance. Tell me quickly, are you a sports person? Do you participate in sport?
Yes. I'm doing sports management.
But do you play sport yourself?
Yes, yes. I play hockey and yeah, I do mostly coaching, but play hockey. That's the sport that I play normally.
Okay. Are you
Yeah.
related to Neville?
Yes, he's my brother.
Oh, excellent! Wow. Um,
Yeah, Avogora is my brother.
yeah. Do give him my fondest regards. I also
Oh,
come from
okay.
a family that are hockey players. But now,
Oh, okay.
for the purpose of illustrating the difference between objective and subjective impossibility of performance, hockey
Yes.
isn't quite going to be able to illustrate that. So let's just, for the sake of the illustration, make you an athlete. You're a sprinter. You run the 100 meters. So let's say,
Yes.
just for the sake of illustrating, somebody enters into a contract with me, Ms. Hanako. Bearing in mind, I'm a 60-year-old
Yes.
overweight lady. They enter into a contract with me that they will pay me $1,000 if I run the 100-meter dash in less than 10 seconds. Do you think I'm able to do that?
Sorry to run,
So they
ma'am.
prepared to pay me, bearing in mind I'm a 60-year-old lady, overweight, I don't run. They prepared to pay me
Yes.
$1,000 if I can run 100 meters in less than 10 seconds. Do you think I
I
can
don't think that's
run?
possible.
In that
No.
case, performance is not
No.
possible because I cannot
Yeah.
run 100 meters in less than 10 seconds. But let's say you are a top athlete, world championship level, training every day, super fit. Is it possible for you to run a sub 10-second 100 meters? Theoretically, you're a top athlete. Can top athletes do that?
No. 10 seconds, 100 meters, and
Yes.
yes, yes, yes,
Yes, yes,
yes.
yes. Most of your top athletes run 100 meters in less than 10 seconds. The difference here, and we're talking here about, to just get back to the law, we're talking about subjective impossibility of performance, which means one party to the contract cannot perform, but other people will be able to. One party to the contract, Hanekom, cannot run a sub 10-second 100 meters. Top athletes, they can. So subjective impossibility of performance, one of the contractual parties cannot do this, but other people might be able to. Just elaborate on my notes here. Running 100 meters in less than 10 seconds, just for the sake of it. When you look at the notes again, in
Sorry.
this case,
Hello. Sorry.
yes, yes, Mr. Gora.
Um, the difference. Which one can discharge contractual uh, obligations?
I'm getting
Is it
there.
objective?
Objective. I'm getting there. You're a
Oh,
bit
okay.
ahead of me at the moment. If the impossibility is subjective, the contract is valid. Contract is valid. Objective impossibility. Nobody in the world can do this. Silly example, but let's stick to running just to compare. Running the 100 meters in less than Make it 5 seconds. Do you think it's possible to run 100 meters in less than 5 seconds?
No, it's not possible.
Definitely not. Definitely not at this stage. That is objective impossibility. Nobody can do this. And in this instance, our contract is void. So, possibility of performance, contract will be void if if performance is objectively impossible. If it is only subjective impossibility, the contract remains valid. Are you with me?
Yes, ma'am.
Okay, great. Let's move on to the next requirement. Performance must also be legal. Performance must be legal. That is actually fairly obvious. It refers to both contracts that are against law, acts of parliament, statutory law. So the performance must not be against the law, both common law or statutory law. So selling drugs, selling unlicensed firearms, anything like that, if it's against the law, the contract is void. Also goes further than just not being against the law. It must also not be against our good morals. An example of that would be if I were to enter into a contract with a young man. Okay, let's think of this. So let's say I have a beautiful daughter. I do have a beautiful daughter. She's happily married. Let's say I decide I don't like her husband, which is not the case at all, but for the sake of example, I decide I don't like her husband and I offer to pay him $1 million to divorce her. That's not against the law as such. There's no act of parliament which says I may not pay somebody else to get divorced. So it's not illegal as such, but you can understand that that is not the type of thing we normally morally as a society approve of. So it's not illegal as such, but will be deemed to be against the good morals, paying somebody else to get divorced because I don't like them, I want them out of my life. That contract will similarly be void. So that is all fairly easy to understand. But with regard to the legality of performance, there is one thing that I need to specifically discuss with you, namely the restraint of trade. Let me get a page reference for you quickly in the notes. That's page 16 of the notes. So firstly, what is a restraint of trade?
Is it not a clause or agreement that limits or restrict someone from uh, limit someone from like their personal freedom to conduct business, whatever the
Absolutely.
profession may be.
Absolutely. 100%. Um, by the way, you do have an assignment which is due. I don't have the date in my head at the moment. The dates are in the course outline.
Is now on e-learning.
The course outline is on e-learning. The assignment forms part is included in the course outline. So if you download the course outline
Okay.
for the semester, the assignment is there. You only have one assignment that you
Okay.
have to do, and then you write a face-to-face test, and you do 2 quizzes as well. Your first quiz is set for next weekend. That's an online quiz. One of the
Okay.
questions in the assignment specifically relates to a restraint of trade. As you perfectly explained it, a restraint of trade is an agreement that restricts you. I'm going to copy and paste to save some time. Agreement that restricts somebody to enter into, to do a specific job for a specific period of time or within a specific geographical area. So you're a hockey player, let's say you're a professional hockey player, and you sign a professional contract with a particular hockey club to play exclusively for them. Your contract with them to play exclusively for them could include a provision that once you stop playing for them, you are not allowed to play for another hockey club for 2 years, or play for another hockey club within Namibia for 2 years. Or maybe it says you're not allowed to play for another hockey club in the whole of Southern Africa for 10 years. You've agreed to this. So there is
Sorry? Yes,
consensus.
yes, ma'am.
Yeah. But now the question arises, is this valid? Is this type of agreement valid and enforceable? Bearing in mind, we are looking at the contractual requirement that performance must be legal. Now, the legality of a restraint of trade is an interesting legal dilemma, so to speak, because it actually brings about a conflict between two legal provisions, both in our Namibian constitution. First of all, I need to go back. I just didn't mention this. Why do we have restraints of trade? Why do people enter into restraints of trade? To prevent, to protect trade secrets, to protect their business. If you are a top player and you suddenly start playing for a competing club, then obviously the club that you left is going to start losing. They don't want to do that. That's why they tell you you're not allowed to do this. So the question is this valid? Brings about a conflict between two legal provisions. In the first instance, in terms of the Namibian constitution, the exact provisions are in the notes. you can go and look at them there. The Namibian Constitution guarantees any person in Namibia the freedom to do any job that they want. Obviously, it uses fancier words than this. I'm simplifying the language now. But our Constitution guarantees the freedom to do any job that they want. But on the other hand, it also guarantees freedom of contract, and that contracts that people have entered into willingly must be upheld. In our free market system, our law is very much in favor of, if you as an adult have freely entered into a contract with somebody else, that whatever you decided, whatever you agreed to must happen. You can't just enter into a contract and change your mind the next day. So our law is very in favor of upholding contracts. Now you will understand immediately that this restraint of trade is contrary to that. Because now it says you may not do your job for the next 2 years in Namibia. So it infringes on your freedom to do any job that you want. But on the other hand, there's this conflict that this is a contract and you willingly entered, you willingly agreed to do this. So if you agree to do it, it must be upheld. So the restraint of trade brings about the interesting legal concept about its validity, because we're dealing now with two conflicting legal provisions. How is this generally solved? How do our Namibian courts handle this dilemma? The general approach by our Namibian courts is that freedom of contract is the stronger value. So if you have willingly and freely entered into this contract must be upheld. So you will be bound. Contracts must be upheld. You will be bound to this contract. If, however, you wish to get out of this contract, you want to escape, the onus, the burden is on you, unless the person who does not want to be bound can prove is unreasonable. Not the contract, that the restraint. Contract, let's make it clearer, restraint. Is unreasonable. By way of illustration, a contract that you may not play for an opposing club, a competition club in Windhoek for a year. Arguably, that would be enforceable. A contract that you may not play for another club for 10 years in the whole of Southern Africa. Obviously unreasonable, because after 10 years as a sportsman, your career is probably you would have aged out of your career. and the whole of Southern Africa, the geographical area, is too big. But if you willingly, to summarize, if you willingly entered into this contract, you will be bound to it. If you don't want to be bound, you are the one that needs to bring the necessary evidence that it is unreasonable because the time period is too long, the area is too large, etc., etc., etc. So this that I've got here in our class notes, this whole thing, I'm going to highlight it for you. That is literally the answer to one of the questions in the assignment. When you answer the question, however, Mr. Gora, don't just copy and paste my notes. I will be sharing these also on the class group, but this is how you will, this is basically the answer that I expect. So just write it in nice sentences of your own. Okay, and then the last requirement. The requirement of formalities. What are formalities? Firstly, formalities relate to the outward form of the contract, whether the contract has to be in writing, whether it must be signed, etc., etc. So tell me quickly, Mr. Gora, do contracts have to be in writing?
Yes.
No. Have you bought anything today?
Sorry?
Okay, it's still early in the morning. Maybe today you didn't buy anything. Did you buy something to eat yesterday?
Yes, yes, yes.
You bought something to eat yesterday. When you bought,
Yes.
let's say, what did you buy?
Chips and cheese rations. Yeah.
Chips and cheese rations. Oh, that's my favorite go-to meal as well. If I don't have time to cook. Did you
Yeah.
buy them at Kleinwindhoek supermarket?
I know, just by Vita in town.
Yeah. Anyway, so when you went and you bought those chips and cheese rations, did you have a written paper with you that both you and the shopkeeper signed?
No, but
No.
it was sort of strange. I got a receipt as proof of, payment for it doesn't apply
Yeah,
as in.
the receipt is just proof of payment. The receipt does not constitute the contract. That receipt did not say that you agree to buy one portion of chips and one cheese ration for whatever it cost you. It's just a proof that you
Yes.
gave them the money. You bought
Oh,
chips and cheese rations. You entered into a contract with the shopkeeper. If you take a taxi to work or to your hockey match, you stand next to the street, taxi stops next to you, you tell him VRS, and he says, and he nods his head, and you climb in, and he takes you to VRS. That is a contract. When you stop there, you give him the $20 or whatever it costs. He doesn't even give you a receipt. You didn't, before you get into that taxi, have a written page setting out all the details and you both sign. The majority, and that is what many people struggle initially to get their heads around. A contract is not necessarily a big formal thing that is typed out and signed and witnessed. Some contracts are, but the majority of contracts that I promise you, Mr. Gora, as an adult man, you enter into contracts every single day. You are probably not aware of the fact that you are entering into a contract. When you go and buy your chips and your cheese Russian, you buy it because you're hungry. You don't think about the fact that this is actually a contract that you're entering into. But it is. If you got sick because there was something wrong with that Russian, you would actually, we don't do purchase and sale as part of your syllabus, but you would actually have a claim for compensation against the shopkeeper arising from the fact that you had a contract with him. Even though the only words that were spoken was one portion of chips and one cheese Russian, please. You have a contract. Contracts in general do not require formalities. A written contract, a spoken contract, a contract entered into purely by way of behavior is still a totally binding contract, provided that these other requirements are also met. You're above the age of 18, the performance is possible, you have agreed to do that, etc., etc. There are some instances, and that is why my notes say formalities if required. In general, they are not required. There are some statutory provisions. If you buy a house, for example, the contract has to be, the purchase of land has to be in writing and signed. A last will and testament has to be in writing and signed and witnessed by two independent witnesses. So there are some contracts that require formalities. If it's a contract that requires formalities and those formalities have not been met, the contract will be void. So if you agree with me that you will buy my house and it's just an oral agreement, that is not valid. But in other instances, even buying a car, you agree with me that you will buy my car for $300,000. That is a valid contract. So formalities must be met if they are required. Any further questions?
So not all contracts need formalities. So, but don't formalities give you a valid validation in terms of that contract?
Not
And
all,
which contracts don't normally need
not all contracts,
formalities?
not all contracts require formalities. An
Uh,
informal contract without formalities is still valid. There are certain types of contracts that do require formalities, but that is the exception rather than the rule. If, however, you enter into a large contract, buying my car, for example, even though it's not a requirement for the validity, it is, of course, advisable to get it in writing so that should something go wrong, it's easier to prove. Problem with verbal contracts is sometimes it might be my word against yours. So the issue of proof might be difficult, but it is still valid. It might just be more difficult for you to prove what the terms of our agreement was. Are you comfortable?
yes.
Okay, that's all I wanted to do for today. I just wanted to finish this particular unit. The rest of, we are now back on schedule. It's just Tuesday. I had connectivity problems. So I had to stop, so I couldn't finish. We're back on schedule. I will download this recording and share it on the group. The other recordings
On
of
the
the
WhatsApp.
previous classes are on the WhatsApp group. Yeah, or on
Okay.
YouTube. I have a YouTube channel where it makes it easier for you to download the
Oh,
recordings. So for classes that you were not able to attend, I hope you have already started watching the recordings.
okay.
Otherwise, if you're playing today, are you playing today? Are you playing a match?
No, we only have a hockey camp on Monday.
Who do
Yeah.
you play for?
Right now I stopped. I used to play for Wanderers.
Aren't you playing for Nust?
No, I did play for them, but I moved to one after.
You moved to Wanderers.
Yes.
Oh, excellent. I'm also a Wanderers supporter. I'll come and watch you at some stage when you
Oh,
play.
okay.
Okay. Thank you
Yeah.
very, very much. Thanks for joining the class. So much more pleasant to
Okay.
actually be able to speak to somebody rather than sit here and just talk to my laptop screen.
Yeah.
Have a wonderful day further.
Yeah.
Okay, take care.
Likewise, thank you.
Bye.
Bye.